Hello, I'm Patricia Hurt, publisher of the Devil Mountain Chronicle. I want to remind everyone of something we sometimes forget. The First Amendment of the United States Constitution gives every citizen the right to petition their government for a redress of grievances, even small counties like ours. That means we all have the right to question government decisions and hold our officials accountable by continuing to ask until we get those answers. That's what I've been doing, not because I'm against raises. I've said before, I think they are justified, but because I care about process, transparency, this county, and the public we serve. Over the past several years, the Texas legislature has worked to erode the foundation of transparency laws by reducing public notice requirements and thus limiting what must be published, casting a shadow on information that formerly sat in sunlight. That makes it even more important to pay attention to the notices that still must be published by law. After looking more closely, I discovered a notice that didn't seem to line up with the statute. I asked a simple question: am I reading this correctly? It's a constitutional right of every citizen. It isn't personal. It isn't political. It's about the rule of law. Transparency is not a nuisance. It's the foundation of trust between citizens and government. And whether you're the publisher of a newspaper or just a taxpayer at home reading the legal section, your right to ask questions is protected. It's not a problem. That's being a citizen. And staying consistent in asking those questions, even when met with silence, is how accountability is upheld. And if any official tries to make you feel like you're wrong for asking questions of your government, that is not accountability. That is intimidation. Asking questions is your right, and exercising that right should never be treated as a problem. Now we're looking at how the Texas Attorney General has read this law and why that matters to taxpayers. We found a few more. JC 0255 says, the salary notice must tell the public the maximum potential increases. If the notice is misleading or incomplete, it is not substantial compliance. GA 0162, if the court adopts pay beyond what a valid notice allowed, that increase is invalid for that fiscal year. And KP 0012 says, after the budget is adopted, you cannot go back and fix a defective salary notice for that year. Pay reverts to the prior year until the next budget. These are persuasive opinions, not court orders. Texas courts often consider them, and most counties take them seriously because ignoring them risks taxpayer-funded litigation. Apply these facts to our situation. The statute does not require a financial scavenger hunt. It does not say publish a percentage. It says publish the amount of the proposed increases. It also does not stop at base pay. It mandates the inclusion of salaries, expenses, or allowances. If longevity pay is an allowance set by the court, any increase to it belongs in the notice with the amount before calling for a vote. It was not there. This is not an opinion. The law says publish the amounts. The notice gave only a percent and never even mentioned longevity, although the court increased longevity anyway. Bottom line, the county acted beyond what it published in the notice. That is exactly the compliance problem GA 0162 and KP 0012 warn about. Would you hire a contractor who says about 5% more, but wouldn't show the before and after price? If the tax office announced up 5%, but didn't show dollars on the bill, would you pay it without question? It isn't about whether raises are deserved. They are. The question is whether the law was followed. And if it wasn't, why? And are you okay with it?